inform him if and when he might be charged. The prosecution's boss told SCOPA members in Parliament yesterday he will not reveal his decision until he's informed the former president. Well, joining us now is criminal lawyer Ulrich Roux via Skype. Ulrich, good evening to you and thank you for joining us. We also understand, of course, that the NPA says we now know they're free to charge the president. What are the immediate first steps that you think must be followed?
Well, good evening, Bongani. If the NPA decide to charge Jacob Zuma, then the first thing would be to issue a summons, what we call a J175 summons, and that would be for him to appear in a court. The matter will then be placed on the court's roll, and he will have to attend to court, and the court case will have to get rolling.
The former president faces a raft of racketeering counts. Could there be any further delays to this process?
I don't think so, Bongani. This matter comes from 2009 already. The NPA has confirmed that they have all available evidence, that all their witnesses are available to testify, and that they are ready to proceed.
It's important, of course.
Previous president was granted an opportunity to make representations, and he was even granted an extension to submit further representations. So I cannot see that there could be any more delays in this matter.
Some are criticizing the move and saying that this is special treatment, the idea that he had to make further representations to try and persuade the NPA from charging him. What's your thought on that?
No, I don't think so. It's obviously a very important decision to charge an erstwhile president with a crime and to bring him before criminal court. And obviously there was a lot of legal proceedings which ensued prior to us reaching this point. There's been numerous High Court applications. There's been numerous appeals. But at the end of the day, all the so-called kicking the can down the road of Jacob Zuma has now come to an end, and the decision is now in the hands of Shaun Abrahams. I think that, if he decides not to prosecute, we could very well see a lot more legal action being taken by the opposition parties such as the DA and the EFF. But if he does decide to prosecute him, then let the previous president have his day in court. He has from the outset said that he is innocent on these charges and that he would like to prove his innocence, and he would like to take society into his confidence and show that he hasn't done anything wrong. So I think the time has come for him to put his money where his mouth is.
The 783 counts of fraud, corruption, racketeering relate to payments made to the former president by his former financial advisor, Shabir Shaik. We also know that the NPA is going to be meeting the acting head of the Hawks, looking at state capture matters. Might we see a scenario in which additional charges might be laid sometime down the road, should he be charged in the very first instance?
The only way in which additional charges can be added to the initial charge, the racketeering and the fraud charge, if it emanates from the same modus operandi and it relates to essentially the same matter. So I don't think that could be the case. He could very well be facing additional charges in a different criminal matter emanating from state capture. But I think first things first, and that is that, Shaun Abrahams must decide whether he's going to prosecute him on the racketeering charges and whether he's going to have to answer to those allegations. One could very well see a scenario later on where he's then charged with additional charges only pertaining to state capture.
Before you go away, Ulrich, in an unrelated matter, the Democratic Alliance has called on the South African Broadcasting Corporation to hold its former operating officer, Hlaudi Motsoeneng, personally liable for the 22 million rand the public broadcaster spent on his legal fees between 2013 and 2017. DA Member of Parliament Phumzile Damme says the SABC should add this amount to the 21 million rand already being recovered from Motsoeneng, taking his tally owed to the public broadcaster to 43 million rand. I mean, what's staggering about this, Ulrich, from what I can make out of it, is that it's almost hard to choose from, the amounts that we've heard relating to the president's legal fees and this 22 million rand that was spent to defend the former COO of the SABC. What are your thoughts on that?
Well, I think a decision is going to have to be made whether he incurred those legal fees in his personal capacity and as a result of his personal vindictiveness in pursuing these charges or these allegations or these court cases, and whether he did so as the CEO of the SABC. His argument, of course, is that in his position as the CEO, and if he incurs any legal costs, then there's insurance which covers those costs, and therefore he should not be held liable. But I think that a clear line should be drawn between incurring those costs as a result of his own personal actions as compared to him acting in his capacity as a COO. And certainly a very difficult decision to be made if it would have to be taken to court at a future stage. I think at this stage, Mr. Motsoeneng won't be held liable for the legal fees, but we'll have to wait and see what happens.
Of course, many would argue that it's easy to become what politicians are calling litigious delinquents when it's not your money. The argument is being made that a lot of these actions were pursued precisely because he knew, like the president, that he wouldn't be held personally liable for whatever costs might have been incurred.
Yes, definitely. And we have a term in the industry called a vexatious litigant, and that is someone who just pursues litigation and court cases at all costs. And I think you mentioned the president's matters now. Towards the end of last year, he received 2 cost orders against him in his personal capacity. And in my opinion, that is the only way in which a public official will learn to be more responsible when it comes to court cases, pursuing certain court cases, defending certain allegations. And that is if they get awarded costs against them in their personal capacity. There are 2 court orders that Jacob Zuma will be held liable for all costs incurred in defending those matters. And certainly that would make him think twice before pursuing such action in future.
We heard from the president yesterday that whatever monies the state will be spending on defending the former president, Jacob Zuma, those monies will be recovered should he be found personally liable. And I suppose it's a similar question to ask in this case as far as Hlaudi Motsoeneng is concerned. What happens if those monies cannot be recouped because the defendant or the accused simply cannot pay them?
One would get a situation where a writ of execution is issued by the High Court, and that then determines that any assets which is registered in that individual's name could be taken possession of by the sheriff. So in other words, if there's R1 million owed in legal fees and he owns a house which is valued at R1 million, then the sheriff is at liberty to take possession of that house, sell it on auction, and then recover the fees for the public purse.
I suppose for you and I, this isn't our first rodeo, Ulrich. I mean, can you imagine if, like we saw, for example, in the case of Oscar Pistorius' trial, if we have a former president, a former head of state on trial, televised for the world to see? What might that imply for our justice system?
Well, I think, Bongani, it will be a watershed moment. Jacob Zuma's racketeering case has come from 2009 already. Now, that is almost 10 years down the line, and he has successfully managed to kick the can down the road on numerous occasions. He has avoided being prosecuted. He has avoided orders being made against him, and it would certainly be very interesting to see him testify. As I said previously, he has from the outset said that he is innocent of these charges which have been leveled against him. And, I think the time has come, if the NPA decides to prosecute him, for the entire nation to hear exactly why he's saying he is innocent. You have a financial advisor who has been found guilty of bribery and corruption and sentenced to 15 years imprisonment. He, of course, has not served a lot of that time, but one would certainly interested to see what he makes of those allegations against him. And I think it would be, once again, as you said in the Oscar's first matter, it would be a very good test of our legal system to see how it performs, especially given that it is such a high-profile individual.
I think from a layperson's point of view, Ulrich, many will say it takes two to tango. Criminal lawyer there, Ulrich Roux, on the line from Johannesburg. We'll have Simon after the break. Stay with us.